So welcome to all speakers and the attendees this session titled Darkness of the Law. I'm very glad to check it. First of all, I'd like to thank Juris Diversitas, of course, and Olivier Moreau for the huge effort he bore. And for us in the panel that I and all the other speakers submitted to the organizing committee of this annual conference. Just to take up time to the presentation, I'll immediately and shortly introduce the general topic of the panel. Before that, however, I give just a few guidelines to the speakers and the attendees. For each speaker, I'll introduce a speech and give some information about their bio and as her turn comes to speak. Each speaker will have 20 minutes. I'll show the desktop in case there are slides or other visual documents to be presented. I'm warning her when more or less 5 minutes will have been left to complete the presentation. For the purpose, I'll raise my hand when showing 5 fingers. However, if the speaker will look recalcitrant or uncooperative or deaf, I will mute a microphone from my Zoom platform. I would propose to divide the panel in 2 blocks, including 4 presentations. When the first block of presentation will be finished, the discussion can start. The attendees can raise the virtual hand, and when the chance comes according to the chronological order requests, each of them can submit a question. And I kindly invite all participants, both the speakers and the attendees, to mute their microphone when not speaking. That's it. Thank you again to you all, and let's start with the panel. As announced, I will synthetically illustrate the general topic, in a sense, the leitmotif of the presentation that will follow immediately afterwards. So our panel is focused on darkness as a consequence of law and the appearance of legal words on the public discursive stage. We are interested in exploring from a multidisciplinary perspective what the light of law makes invisible. So in many cases, what becomes invisible as a consequence of law is implicitly overshadowed, if only because it exceeds the semantic borders of both what is included in legal categorization and what is excluded as their opposite. The darkening effects can impinge on many aspects of daily life, engendering discrimination, domination, oppression, inequality, discontent, etc. All this has to do with what we consider the darkness brooding after law's semantic light. The panel papers will consider this silent injustice germinating in the shadow corner of both the majesty and the ignorance of law with regard to the obscured aspects of social life. That said, I'd like to present immediately the first speaker, that is Peter Peckhoff. Peter Peckhoff is a law lecturer at Brunel Law School and director of the Religion, Law and International Relations Program, a collaborative international research network at Regent's Park College, Oxford, in which capacity brings together lawyers, theologians, philosophers, and social and political scientists to develop innovative interdisciplinary strategies for studying law, religion, and international relations from legal and theological perspective. That said, his presentation is titled The Unknown Between Vagueness of Law and Legal Certainty, Apophatic and Cataphatic Strategies in the Imagining of the New Legal Frontiers. So I give immediately the floor, the virtual floor, to my friend Peter. Please.
Your alter ego. Hello, everyone, and I'm delighted to speak at this event, and I'm even more delighted that Zoom has chosen to make me appear with the name of my dear friend Mario Rica, and I'm greatly honored, but I'm not quite sure whether I'll be able to step in his great shoes, but I'll do my best. Now, with this, I also want to raise one caveat, and I hope that you're not going to discover by the end of my presentation that I'm probably the worst person to start this session, partly because when I looked through the program, I realized that I appear to belong to a minority of speakers who have interpreted the dark sides of the law as something which enriches the idea of law, something which enriches the quality, and in a sense I interpret as good rather than a shortcoming of the law, not because I love the album of Pink Floyd, but because for a number of years I have been very interested in the ambiguities in law from a historical perspective, but also in the ways of how at the time when certain premises of modern law have been challenged unprecedentedly, such as the traction and the legitimacy of international law and liberal internationalism, the legitimacy of international human rights, the tensions between universality and subsidiarity, the tension between emphasis on the context of a treaty and its teleological purpose, the tension between forum internum and forum externum, and the tension between legal certainty and the vagueness of law from methodological and philosophical perspectives, I began to realize that in different settings and in different legal contexts, there has been a rethinking of what the idea of law, the idea of legal system, the idea of legal discourse represents. And there have been certain increased interest in looking into law more from dialogical perspectives, as narrative, as something which is a container of memory, something which is not just a normative system, but also a normative landscape which penetrates a much more complex set of relationships which go beyond a specific legal context of rights and obligations. And in this context, there is certainly an emerging discourse that, as opposed to the German concept of legal certainty, we ought to think of law in terms of the vagueness of law. And this is certainly a premise which has been articulated very strongly in the context of the Oxford School of Legal Jurisprudence, particularly Timothy Endicott, who in his book of Vagueness, The Vagueness of Law, he looks and reclaims some of the premises of Wittgenstein, that language is a family of meanings, and legal language in particular is an extension of that. And he argues that law is very commonly vague, that the requirements of the law in particular cases are frequently indeterminate. Vagueness and reluctant indeterminacy are essential features of law. Although not all laws are vague, legal systems necessarily include vague laws. When the law is vague, the result is that people's legal rights and duties and powers are indeterminate in some, if not all cases. And then he looks into how the role of the judges in many ways is really balancing between the ambiguities of the legal language in trying to really come with an equitable judgment, with an equitable interpretation of the rights and duties in place. Now, this, of course, is very good in terms of presenting it as a subset or as an extension of the Oxford tradition of legal positivism, but it doesn't always work in all cases, because it raises a number of methodological questions of, if you balance, how do you balance those ambiguities, particularly when in philosophical terms there are negative as well as positive strategies of asserting what things are, as well as asserting of what things are not. And as we have seen most recently with the increase of right skepticism in terms of philosophical discourse, withdrawal towards sovereignty, and reluctance to reaffirm the international legal order which was created after the Second World War. The whole debate about whether international law protects states from one another or whether it protects human rights, and how do you balance this particular tension? Or, as we see in the increasing challenges of human rights in the so-called culture wars, the lack of methodology of doing this balancing tends to really shift things into different camps rather than achieving the balance of which Endicott talks about in his work, and the balance which Wittgenstein largely discusses in his theory. Now, but this immediately, when I was reading his text, that immediately occurred to me that this is a discourse which is a very with which we feel very much at home, particularly if we had wasted endless hours trying to make sense of history of medieval canon law. And Franzen, talking about the evolving of the legal tradition in Europe in the Middle Ages, makes a very similar point about the fluidity and the vagueness of legal norms, looking at them, particularly up until the 13th century. And he argues that perhaps until the end of the 12th century, an ecclesiastical judge was not a professional because he did not have a sense that he applies positive law issued by authority. And with his advisors, he seeks out the just solution of a problem before him. In doing so, a medieval ecclesiastical judge has to work with law which has not to be found in any defined corpus of text and which may be found anywhere throughout the inherited Mosaic and Christian tradition, with relevant passages which often appear to speak in discordant voices, reflecting differently in numerous local normative compendia what the rules were. And in a sense, the judge saw himself more as appealing to the sea of tradition, where the different rules and different principles, different normative ideas speak in dissonant voices, and something has to happen to really reconcile those dissonant voices and apply such interpretation in relation to a particular case and to a particular context. And that's not dissimilar from what authors like Josipovici or Bernard Jackson or Jonathan Burnside speak when they speak about the reinterpretation of the tradition of biblical law, seeing it more as a dialogical scheme rather than a rule of law with teeth which is applied on the ground in particular cases. Expanding the interpretation of legal traditions, not so much as technical, instrumental legal systems which are applied in the way our modern legal systems are applied, but legal systems which have much wider and more complex platform, largely dialogical, very often articulated and linked with memory, with repetitive rituals, thus demarcating a sense of identity, but also a sense of authority through this repetitive reference to rules and obligations. And in that sense, applying of the rules is as important as repeating the rules as part of a particular ritual or as part of a particular existential encounter. And in this way, the rules become something more than just rules which are technically applied as a Swiss Army knife to fix a particular problem at a particular moment in time, and have a much wider existential purpose. Now, when I was looking how these different traditions were dealing with the challenge with which we deal today, I was particularly attracted by the tradition of apophatic and cataphatic theology, which is strongly associated with the tradition of the Christian East, and refers to the theology of Dionysius pseudo-Areopagite, a very Platonic figure, but eventually becomes a mainstream way of thinking about normative framework and thinking about our knowledge of the divine. And because law was seen as an extension of the created, the divine grace in the created world, it also became a way of thinking about metaphysics, but also thinking about substantive law the way we understand it. And this method, which is very similar to what we may be familiar by the Platonic tradition, but taken to a different dimension in a Christian context, is really looking into this ascending and descending intellectual strategies of building a positive scale and combining it at the same time with negative philosophical and theological strategies. So in order to understand what God is, we also have to understand what he isn't. In order to understand what law is, we also have to understand what law isn't. But this is not necessarily structured metaphysical frameworks, but they're also taken to an existential level, that in every context, at every level of which we apply a particular attempt to understand a particular rule, particular norm, particular concept, we have to scale up and scale down through this negative and positive strategy. So it's a very dynamic understanding of knowledge, which takes you through the up through the positive ladder, but the closer you go to an understanding, the deeper you go into the darkness of the unknown, that you cannot have a complete and perfect understanding. And working your way around these two dimensions is eventually bringing you at a kind of existential level to what in the Dionysic tradition is the dazzling darkness. It's level in enlightenment and understanding where everything clicks through this almost perpetual linking of positive and negative intellectual strategies, and acquiring perhaps the balance of which the contemporary Oxford positivists are talking about, when the judges really crack it and are able to reach this balance and come up with a particular judgment. And what occurred to me is
4 minutes left, Peter. Sorry, 4 minutes.
How many?
4 or 5 minutes.
Very good, thank you. And what struck me was that we have lost through in our normative thinking of having the ability to really think about norms in that scale, looking into things into what the norms are, as well as what they're not. On a textual level, freedom of religion or belief, freedom of expression are linguistically scaled to help us think along those lines. But for one reason or another, we don't do this in practice. We always separate the negative and the positive dimensions of particular right. There is always a pressure for public authorities to exercise neutrality, but there isn't really a pattern through which one could help them understand how this neutrality could be built, whether it's built through positive or through negative intellectual strategy, or with a combination of both. And I therefore thought that legal theorists and certainly legal philosophers or legal semioticians who are more interested in looking into what texts mean, how they could be interpreted, and what are the intellectual strategies which could be deployed in this context, could learn a lot from reclaiming the Dionysian tradition of scaling negative and positive intellectual strategy, not as something you do selectively, but something you do in conjunction, you do simultaneously, and create this dynamic balance which help us to identify the scale in which legal rules operate, not only in relation to a particular legal dispute, but also have the wider and more narrative existential outreach and interaction with the humanity as a whole. This is not an attempt of theologizing of law, but it is certainly an attempt of reclaiming something which we always had and have somehow abandoned with the tradition of claiming that modern law has just moved on and is part of a rational evolution. In fact, in many contexts, particularly with focusing on reclaiming subsidiarity or focusing on reclaiming the decodification of Catholic canon law, for example, there is a re-emerging appeal of this more existential, more dialogical way of understanding the law, more dynamic way of understanding the law and the way it works in different contexts simultaneously. But there hasn't been so much emphasis on methodologies through which this could be reimagined. And I thought that reclaiming the dark side of the law as a dazzling darkness, dark as dark as it is enlightening, may be a good starting point. And on this, I shall end. Thank you, Maria.
Thank you so much, Peter, for this in-depth and insightful presentation. So I pass immediately to the next speaker. Is Melissa Vasquez. Her presentation is titled "Seeing Each Other Playing Law and Identity in Miserable Darkness of a Yugo." Melissa completed her doctorate in theory and legal system at the University of Rome, La Sapienza, with a degree in comparative literature from Brown University and a background in several languages and cultures. She's interested in intercultural legal translation as a lens through which to assess and explore creative interdisciplinary solutions to contemporary global conflict within law and religion. Her most recent publications include Secularism, Religion and Law, and a Legal Culture Inquiry. So I give you the floor immediately. Please, Melissa, start.
Thank you. Thank you very much, Mario, Rica. Thank you, everybody, for your time and attention. Okay, I'm going to try to share some slides here. Okay, let's hope that it works.
Okay.
So you can see?
Yeah.
Okay. Okay. So in a way, I'm going backwards from what we just heard from Peter, because he was talking in great depth and sophistication about how do we address these problems that are then generated by what I would like to address today. My contribution here today is in the area of law and literature. And I want to use a couple of characters, protagonists from Victor Hugo's magnum opus, Les Miserables, in the most recent English translation called The Wretched, to look at questions of law and justice and propose one aspect within this realm as a dark side of law, which, as I said, it's sort of the precursor, I think, to then the solutions that Peter was speaking about. So I'm going to start from the premise that law punishes delinquents after having made them such. So in the famous ought-is divide, law belongs to the domain of ought. It prescribes behavior, it passes judgment, determining what's in and therefore accepted, what is out and therefore rejected and punishable. But since it's law itself that determines the rules, it also defines delinquency. So in this sense, it makes someone delinquent by identifying them as such and then punishing them. So we can see this dynamic clearly if we think about citizens versus immigrants, or revolutionaries versus terrorists. So we could say that a migrant in some way is a failed citizen, and a revolutionary is a successful terrorist. So in that sense, what does it mean to be delinquent in the eyes of the law? So delinquent, of course, comes from the delinquere, so to fail, to fall short, to do wrong, to transgress, to be wanting. So when something, a behavior in this case, is found to be wanting, it's because a behavior not completed was wanted by the law, by society that's constituted and legitimized that law. So the individual actor fails to satisfy a want, a desire. But of course, to be wanting is also to lack. And those who transgress the law are very often those who lack. And therefore, they seek to obtain what they lack through their transgression, not only materially, as in the case of theft, but also abstractly, as occurs in illicit attempts to gain power or status. So those who are found to be wanting are also wanting. And it's this doubleness, this failure to sit still, our definitions of behavior that in the end mirror one another, that I'd like to address today. So I asked the question, is a person without the means to provide for themselves, to be self-sufficient, delinquent? Is a person who's unable to make their way in life without infringing the law delinquent? We don't need to repeat again the well-known facts about abusers who were in many cases abused themselves as children. A person who becomes physically enfeebled through substance abuse, substance dependence, are they delinquent? So there's an old joke that says, don't give the bum money, he's just gonna spend it on alcohol. And then the other person says, that's what I was gonna spend it on. So which side is delinquent? What about a person who infringes the law so as to earn a living? The fact that some countries hold the prostitute to be delinquent and others the client demonstrates that we're uncertain internationally about where to place accountability. And finally, I think that people who are forced out of their home countries are typically driven by all kinds of persecution. So when do they become delinquents? Do they transform into delinquents the moment that they cross the border, the moment that their behavior transgresses the law? And if so, how long do they remain delinquents? So we think of the term economic immigrants, it's used disparagingly to speak of people who move for a better economic situation, as if moving countries to find work to feed your family were some kind of a technical move, as opposed to an attempt to survive or even scandalously flourish. So when people's conduct is wanting, it's typically because they are wanting. All right, so how is this relevant to law and literature? So my second premise is that law rules and literature imagines. So I think literature is instructional in this way because whereas law is tasked with rules and governance, literature's primary role is to imagine, to unfurl narrative paths and bring to the surface individual realities and struggles. So law adjudicates stories once they're already underway. Literature recounts them and reveals their complexities. And since they're both tasked in some way with making sense of people's behavior, I think they can be mutually informative. So I was speaking with a friend of mine who's an engineer, and he said, you're going to use fiction to talk about law, right? Because there's this idea that they're completely different animals, right? One is about stories and it's invented, he said. And I said, but so is law. He said, what? And so one way that I justify this choice is by explaining that there's this book called, that came out in 2017 called The Novel of the Century, The Extraordinary Adventure of Les Miserables. And the author actually recounts at least 4 different legal occurrences in France that he attributes to the publication of Les Miserables. So empirically, he claims, after the book was published, France changed the law about internal passports. So convicts could re-enter society without a permanent black mark on their names. And this is related to the protagonist, Jean Valjean, who has a yellow passport, which marks him as a convict forever. And that sets in motion all the events of the book. The second thing is they amended the penal code to recognize crimes of necessity, so that people who were stealing bread to feed their families, as in the book, would not be sentenced to hard labor as a consequence. The third was that they created more employment for the uneducated. And then finally, he ascribes the building of more schools for the poor, making elementary education universal, obligatory. So there may be a case to be made that law literally empirically changed as a consequence of this particular piece of literature. But in any case, my interest is more theoretical. So this is a quote that I've translated into English from Hugo's French. Literature begins by shaping the public and then makes the people. To write is to govern. Of course, Hugo was not famous for his humility. So I suspect, I guess you can say this is a bit of an overstatement, but there are narrative bridges. So each domain, law and literature, contains stories of people's lived experience. And Les Miserables takes on no less than the very meaning of justice and criminality, the adjudication of good versus evil conduct. Okay, so I'll try to get through this quickly because you're probably familiar with the story, but the two protagonists, Inspector Javert is the face of the law. He sees one path, the path of legal justice, and he's up against Valjean, who is an everyman. He's born to poverty. He's condemned to infringe the law to survive. He serves 19 years in prison doing hard labor for the crime of attempting to steal bread to feed his family. And it's interesting to note that in France in 1860, the average life expectancy was 40 years old. When Valjean is released from prison, he's 45 years old. So in a sense, the entire life story is on borrowed time. You know, it's like a second life that he's granted. And in fact, he has an epiphany, meets a bishop, and he determines to transform himself and spend the rest of his life doing good. In order to do that, though, he can't be himself. He has to create a new identity, which of course is illegal. And so Javert, the face of the law, cannot accept that this attempted transformation takes place. Once a criminal, always a criminal. False identity, it's only another crime. It doesn't matter what good comes from this transformation. He doesn't rest until he has Valjean in his hands, right? As it happens, circumstances are such, revolution, Valjean is tasked by the revolutionaries to kill Javert. Instead, he spares him. And not only, he tells him where to find him after the war so that he can be arrested. So he submits completely to the concept of Javert's authority. Javert, however, and this is sort of the crux of the position that Hugo takes on justice and innocence, excuse me, is that when Javert, the law personified, realizes that his singular path of law and justice is in fact not singular, and that the criminal, Valjean, has saved his life, that he, the law, is indebted to the lawless, his moral compass short circuits and he commits suicide. So it's a perfect illustration of the dark side of the law. When law is so rigid that it substitutes the truth up to this moment, the truth so far, with the truth evermore, it becomes blind to the realities of the people it's meant to protect. It becomes ridiculous. It loses every pretense of legitimation and then becomes incapacitated from accomplishing its self-imposed goals for order and control. So Javert, who spends his entire life with this singular purpose, realizes in that moment that they've reversed roles, and he who was meant to be the bringer of justice is in fact being brought to justice by the criminal. And so finally, the idea that an adjudicated thing is regarded as the truth is one way of articulating this particular type of darkness. So when an adjudicated thing becomes solid, it's as if ought and is become fused into one lethal entity that is pointed directly at the defenseless. It no longer stands for justice. Its aspirations, or at least its mistaken identity with permanence, make it so that it no longer codifies reality, but instead bashes it down into preconceived categorical cages. It loses sight of even the most fundamental human needs. This is how someone who's trying to survive by stealing bread ends up in prison doing hard labor for 20 years. So as a kid, I used to use encyclopedias to study because we didn't have the internet, probably many of you as well. And I think that despite law's attempts to modernize, it's still more this than digital in its essence, in its way of being. Of course, it's impossible to avoid. Law builds and depends on semantic encyclopedias that structure, make sense of behavior. Its volumes include contracts, personhood, good faith, compensation, inheritance, property, etc. Each of these is built on lived experiences, adjudications. But look at the leather. Look at the bindings. Those formulations are trapped on printed pages. How do you add algorithms, memes, video footage that captures a man being strangled by a police officer? So being less dramatic for just a moment, I took a look at a recent law in the UK, the Data Protection Act, to have a look at some of the legal language, some of what Peter was getting at, this idea that in order to protect data, we must use personal data fairly, transparently. It has to be adequate, relevant, kept for the period that's necessary, appropriate. These are all the kind of vagaries that in its best guise, law uses to its advantage. We need these kinds of words. We need these vagaries, right? In order to make space for interpretation, in order to adjust and adapt according to the specifics of the
5 minutes left,
issue.
Melissa.
No problem. I'm almost done. So we need the vagary in order to make law effective, right? But too often, what happens instead is that law solidifies. So crimmigration is a term that's been used to try to capture this kind of reification, okay, this reification phenomenon in which once a person is branded a criminal by virtue of illegally immigrating, every act thereafter is tinged with a kind of yellow stink of criminality. So just now, end of May, the US Supreme Court adjudicated in this decision, Palomar Santiago versus United States, specifying that even if a migrant was illegally deported, they cannot defend themselves from federal immigration crime prosecutions that require prosecutors to show that they were previously deported. So in other words, they have the mark of a deportation on their record and making their future judgments worse, even if that deportation was itself illegal. Even a deportation that shouldn't have happened can trigger a felony conviction. In other words, once an offender, always an offender. So I just want to end on this quote from Castoriadis. A just society is not a society that has adopted just laws once and for all. Rather, it is a society where the question of justice remains constantly open. So that law becomes fact, it's normal, it's inevitable. But when it remains fact, then from the macro level, it's problematic. Because the assessment then of new facts, the rethinking of new realities, are impeded by the cumulative effects of the past applications of the law. So the existing grammar conditions the reading of new narratives, and law becomes a social determinant. It determines how people think of what is. So when law makes that sort of dangerous slip from ought and into is, then we no longer can see the effects of the law. They're not distinguishable from the law itself. Once you see the result, a convict, an illegal immigrant, a homeless person, you don't see anymore the law and the social forces that led up to that circumstance, that were co-involved in making that result. We can't distinguish anymore which part is subjective, which part is objective, once they're merged. And then law becomes like an arsenal of weapons that are always missing their mark, missing every opportunity to provide justice. Only justice obtained legitimizes the law, but the presumption of already being leads to failure. So I think this is one side, one dark side of law. And the possibility of light would have to do with watching out for this melding of ought and is, and resisting the blindness that comes from ignoring the semiotic webs that underlie every legal determination and every new case that's brought before the courts. We have to insist on pushing legal interpretation towards an openness, a vagueness, as Peter was saying, a constant renegotiation of the terms of the social contract, one that isn't crippled by what was, but instead leaves space for becoming. Thank you.
Yeah, Lisa, thank you so much for this presentation about not only the darkness, but also the mournful aspects of the passage of the law from the past to the future. Thank you. So I immediately pass to the next speaker. She's Mircea Bianca. Her presentation is titled Cyber Law and Effectiveness, a Private Law's Perspective. Mircea is full professor in private law institution and private law and communication, ethics and journalism law at Sapienza University. She addressed in his long career a lot of topics, right? The private law, civil law, and constitutional topics like freedom of speech, and particularly the rights of the members of the family, and family law, in fact, is a specific topic in which is very, very specialized with the super skillfulness. So I immediately give her the floor. So please, Mircea, you can start.
Thank you, Mario. Thank you to you all for the invitation to this important conference. And the title is more important, the dark side of the law. And the panel of this panel is Darkness After Law. And I want to thank Mario, my friend. And the subject of my speech is the cyber law and effectiveness. But first of all, I want to show the strange relationship between feelings, effectiveness, and law. Because in a traditional perspective, law and all the world of emotion are out of law. Law doesn't care for feeling, doesn't care for love, doesn't care for emotion, and doesn't care, I could say, for human being. That is strange, because, you know, in a substantial doctrine, the final goal, the final destination of law has to be human being. And we cannot deny that the emotional part of us is the most important part of human being. There was a very important civil lawyer, which is Angelo Falsea. He was born in Messina, the same city of Mario Ricca. I am Sicilian as well, but I was born in Catania. And he says he belongs to this formalistic perspective. And he said that love, feelings, emotions become important for law only when they become a disposition, a legal disposition. And so they become values recognized by all the society. But I want to dedicate this speech to my father, my beloved father. He was a civil lawyer, private lawyer, and he belonged to another doctrine, which is the substantial doctrine, which he believed that human being is the best important thing of lawyers, and he is the final destination. And the methodology of his thinking was the principle of effectiveness. Before I have we could say that I listened with very, very interest in the relation and the presentation of Melissa Vasquez. And it was the contradiction between the fact and the law. Sometimes law is outside the person, the people, outside the justice. It's only law, it's only the disposition. And in the principle of effectiveness, but my father was not the only one. There is a book published by Nicola Lipari in these days, which is called The Elegy of Justice. And it goes against this formalistic perspective of law, like something that does not care emotion, human being, and the needs of human beings. But I want to come to the cyber law, because in cyber law, this relationship with effectiveness, it's even more difficult, because nowadays debate is to say that algorithms, machine, robots goes against human being. There is a dehumanization of man, because Stefano Rodotà told that there is the dictatorship of algorithm. The machine, the robots are against human being. But I want to show a light of cyber law, because one of the last challenge of robotics is to create robots which copy the neural synapse of human beings. And so they recreate the same expression of the face of human being: anger, happiness, sadness. They create emotion of human beings. And then that is very interesting. In Japan, there is a research in which robots create the same way of walking of the emotion. You know that when a person is very, very angry, he walk speeder. And so they recreate this kind of emotion. They call social robots, domestic robots. And why I want to say that? Because they use these robots for social activities, for companion of elderly people, for ill children in the hospital, and for the people with disabilities. And there is, in this day, I am reading a novel of Kazuo Ishiguro. It's famous for another novel, which is The Remains of the Day. But the last novel of this author is called Clara and the Sun. And Clara is a robot of the last generation, and which is empowered by the sun. She lives with the sun. And this robot became and it's very touching in the novel, because she becomes the best friend of a young girl of 14 years old, which is very, very ill. And in this robot, you can have some emotion more than a human being. And then I want to show other challenge of the artificial intelligence. In the last years, we and other lawyers and judges have tried to apply algorithm to quantify the alimony in case of divorce, in the sense that the algorithm can help the judge, not substitute the judge, but can help the judge to give some details and some information and to quantify the alimony. And another application in these days after the pandemic was the little marriage. There was, some days ago, there was a conference of my friend Fulchiron in Lyon, and it was called, Shall We Go Towards an E-Family, a family made, the relationship made by internet. And in the case, they were speaking about this little marriage. The little marriage during the pandemic was the marriage made by internet for people that couldn't come in presence. So it is another light of artificial intelligence. But there is the last one, which is the most important for me. And then I go to the conclusion, Mario, don't worry about that. That is the fact that in the field of data, the person can survive. We have an immortality identity which goes beyond our material life, because and there is a very beautiful paper of Melissa in Calumet, because one darkness of the law is the fact that when a person is dead, he or she loses the legal capacity. And a very, very great shadow is given by our Supreme Court, because you have to imagine that when there is an accident by the fact of a third person, and the person loses life, you cannot have the compensation for damage for a formalistic reason. Because for law, nowadays, not in the Middle Ages, but nowadays, the person loses legal capacity. And with losing legal capacity, he loses the right to have the compensation for damage in the case that, in the case in which the damage is the losing of the life. And, I think that, but it's my opinion, that all these conferences give a light for the mission of lawyers. And the mission of lawyers is to have and to see the final destination of law. And the final destination of law is human being and justice. And if we miss this mission, we are useless, and law is useless for the society. And so thank you very much to you, and sorry for my English. Thank you.
Thank you, Mircea. Thank you so much for this pioneering speech, and in a sense launches the private law and civil law and the thought about the civil problems in the future beyond the categorization of the present legal experience. But so much injustice could bring in itself, just for its blindness with regard to the novelty of experience. Thank you sincerely.
Thank you.
So we pass to the next speaker. She's Elena Iuriatti. Her speech is titled Light and Shadows of Multilingualism and EU Citizenship. Helena is full professor of comparative law at Trento University, and her main research activities focusing on law and language, legal translation, comparative private law, European private law, a lot of topics. But what is important is to notice that in 2017, she presented her research outcomes on EU multilingual meta-concepts at the Accademia Nazionale dei Lincei in Rome, and that she has been local coordinator and member by the executive board of the European project, the BU Citizen, a consortium of 26 universities, among them Oxford University, Goethe Institute of Frankfurt, the London School of Economics, and Hebrew University of Jerusalem, coordinated by Utrecht University. So I don't waste the time that Juris Diversitas gave us, and so give immediately our virtual floor to Helena. Please.
Thank you very much. Yeah. Thank you, Mario, for this invitation, and also thank you for all the stimuli that I always gain in our discussion. As I always say, I'm the only one who gains something when we discuss. So thank you very much. I will try to share the screen. Okay, so when Mario suggests me the title of this speech, I immediately remember the aphorism of Goethe, there is strong shadow when there is much light. And this aphorism, I think, is really visualize the light and shadow complexity of the European multilingual legal discourse. And because as we all know, EU multilingualism in its normative feature is the maximal word attempt of creating normative common context of meaning under the umbrella of a democratic linguistic regime. The EU is constantly emphasizing translation as a tool, a democratic tool, that it grants the creation of a bundle of rights that is clearly knowable and enjoyable by each single European citizen. But the point is, beyond this shimmering propaganda, does really normative multilingualism correspond to a real common enjoyment of EU rights by all citizens in the member states? Or multilingualism that is also made of translation, but it's not only translation as it is meant to be at the European level, darks some of component of the EU citizen rights by marginalizing some rights. And as you have already understood, I'm rather critical about the way in which multilingualism is handled at the European level. But in this speech, I will shortly describe some of the positive and negative aspects of EU multilingualism in terms of light and shadow. But then I will try to show a possible way to follow it. It will be just a proposal that I would like to share together with you. So I'm going to start with light. Speaking about multilingualism implies mentioning its first ingredient, that is the language. As Jesse Kirby noted, it is astonishing that extremely complex concept of morality, ethics, science, and technology can somehow be put into verbal sounds and then cut up into little pieces known as words and sentences. So Justice Kirby qualified as a miracle the fact that human minds can convey meaning to each other. This miracle that is known as communication would probably go unremarked were it not for the uncomfortable discovery that other people speak languages different from one's own. So invoking communication as a miracle make us aware that people really realize the existence of language, of their own language, and the human ability to communicate at the very moment in which they can't communicate anymore because of language diversity. So a positive aspect of multilingualism is that of having encapsulated at the European level language diversity into the structure of this rather recent legal system that is the European Union. So EU citizens, beyond, of course, tangible benefit, like having the possibility of communicating their own language, they constantly live in an environment where the necessity of bridging the gulf of differences, and not only language difference, but even cultural difference, is part of the game. So we, as people, judges, lawyers, scientists, we live in a reality in which we are constantly crossing borders by means of bridge. And we bridge diversity, and this is has to be made inside or also outside the legal sphere. But unluckily, there are also shadows in this positive environment. Because the point is that it seems that the only bridge on which the European Union is relying is the legal translation. And in the normative process, multilingualism is a sort of synonymous of legal translation. So we have this unremarked overlapping between translation and multilingualism that has substantial consequences. This is particular because this translation is not a real translation, but it's creating a sort of new legal language that de facto artificially constructed at the European level and is it is encapsulated into the new EU legal concept that is called EU neologism in a sort of semantic meaning that is imposed from above by the European Union, but is supposed to be common to all the member states. So, as we will see in a while, in the reality, this is not really bridging diversity, but the diversity is really recomposed at the national level. Because we have a sort of constant flow of contextual meaning at the national level that is sort of floating under this bridges, that the European Union is supposed to build up. But in the reality, the European Union is not creating bridges, but a sort of one-way road that is imposed on the member state. And this context of meaning that are already present, they simply need to be visualized in order to make them effective to all the EU citizens. So, from a technical point of view, the translation at the European level is handled by a translation machine that is one of the most advanced in the world. It is equipped by highly specialized professionals like the lawyer linguists, so nothing to complain about that. The point is that what is completely abandoned by the EU institutional vision is that values and cultural diversity are encapsulated into the national legal languages. And so this is simply the tip of the iceberg of the national legal traditions. And the situation is really different from the one, for example, of the USA, because also in the USA, handling cultural differences is, in the legal sphere, is a permanent ingredient of the American dream. If we think about the restatement of the same constitution, it is clear that this is part of the rule of law in the American legal system. But the point is that this ingredient is blended always with the same language, that is English. Differently, in the European Union, the national peculiarities in law need to overcome also the language barriers to contribute to any possible common space of culture, or to what Mario Rica defined as a European common space of justice, or better, an interspace of common justice. So in the legal sphere, EU multilingualism should not be a synonymous of legal language or translation, but of legal language multiculturalism, and not of translated law, of course. Nevertheless, the European Union is going on with the creation of neologism. And these neologisms are qualified by the European Court of Justice as autonomous concept, because they are supposed to transfer the same meaning horizontally across the languages, and also to be interpreted and applied uniformly at the national level. From my point of view, this is a sort of objectivization of the legal court of national member states. This context, this new concept are a sort of abstract term. They have no meaning if they are left at the European level. They have to be interpreted and applied at the national level to acquire a real meaning. And I'm not going to bother you with example in private law, but if you think about the Directive on Consumer Rights of 2011, there we have a very crucial word that is property ownership, because the consumer became the owner when the delivery occurred. But the delivery is a European concept that is linked to another European possession. But delivery and possession are abstract European terms. But at the same time, the possession is a very crucial term at the national level that is interpreted in different way, and it has different meaning, even inside the same ordinary language. Because if you think of the word Besitz, it has a meaning in Austria and another meaning in Germany. So the point is, when the consumer became proprietario at the European level, depends on how this word is applied in the member states, and it applied in a different way. And this is the right to property that is a fundamental EU citizen economic right that is recognized by the Charter of Fundamental Rights. So this is a huge gap at the European level. So the point is that in this framework, law is a tool. The language is a tool. This is the underlying problem of how multilingualism is handled at the European level. Because Europe is an international organization having a specific aim that is still the single market. So the law and language are instruments that are used in order to complete the common market. And so this is, in this mechanism, objectivizing the meaning of the term is not only a technique of translation, but it is also a strategy giving the possibility to maintain the control room in Brussels. Because handling this situation by means of terms that are completely disanchorated by the legal quarter of the member state, given an enormous space of maneuver at the European level. The member states, I'm not saying that the member states are not involved in the normative process, because they are. Because the legislative procedure is shared, as we all know, by the Commission and the Parliament by means of the co-decision procedure, and then it ends up in the Council with the vote of the member states, so the member states are represented. But we all know that having a role in a political process leading to a directive or a regulation formulation is something very different than being involved in a multi-language cultural process. So the consequences of this way of handling multilingualism at the European level is that economic interests have precedence on values and culture, and that European citizens are not really at the center of the European legal system. So, from my point of view, the EU normative multilingualism is handled as a sort of magic box in which everything is apparently easy and possible. So the question is, can we simply get out of the box? Yes, we can, by simply observing the reality. Because the operation of the magic box assumes that the EU is a system of norm to which national law are hierarchically subordinated. But this positivistic view is only one of the ways in which the relationship between the EU and the member state could be described. From a different perspective, the EU legal system could be also qualified as a shared supranational polycentric institution, producing norms according to the institutional interaction between the national and the European level. And in this more realistic and dynamic approach, national grounding forces, so the court interpreting, the legislator transferring EU law in the member states, the doctrine discussing EU law, they can contribute to the construction of the meaning and of the EU conceptual structure. And this is, in comparative law, this is what we qualify as formants. And the point is that EU law is interpreted, it is transposed in the member states. So the national grounding forces, the formats, are working on that. They give an interpretation, they give a contribution to the completion of the concepts that are elaborated at the European level. I wrote an article on that, and I shared some impression with Mario. And this article is demonstrating, I hope, that in a very important, crucial area of EU law, like property law, the word possession, that is an artificial word, a neologism, is completely empty at the European level, is filled up by the interpretation of the court in the member state, and also by the result of the transposition of this waste directive at the national level. And all these efforts demonstrate that the member states are able to handle their diversity and to address this diversity in order to give a common meaning to this concept at the European level. So a concept that is abstract and is crucial at the European level, possession, is filled up thanks to the contribution of the culture of the different member states.
5 minutes left, Elena.
Yes, I'm going to conclude.
Thank you.
So the point is, if we look at the interaction between the European and the national level in a more profound and realistic way, the focus should not be placed on how each EU law is hierarchically completed by each national court or transposed by legislator at the national level, but on the visualization of a constant and that each single legal system is veiculating by the format into the national level. So common context of meaning do really exist in Europe, and they are slowly composing a shared European normative and conceptual culture. The only point is, how could we find a way to orient all these assets of this cultural assets towards a common supranational level? We could do that by relying on legal education. So by teaching to the student, to the professionals, what is really already existing at the European level, or perhaps by converging all this information in a sort of European restatement. So reality is in the sunlight. It only has to be visualized. So thank you very much for your attention.
Thank you, Elena. Thank you so much. The question that is rising from your presentation is how much injustice, how much that law is concealing in the fault of the passage from national level and European level and back. So it's an invisible law. It's concealed precisely by this passage. It's the passage in itself. Thank you so much. So Elena, we have concluded the first block. So I ask if someone want to raise some questions to the speakers. You can raise the little hand that you're at disposal. Is in reactions at the bottom of the video. If there is none that want to raise a question, so I immediately pass to Paolo Ridier, that is the next speaker. His presentation is titled "After the Cave, the Dark Screen of the Norm," such a Platonic reminiscence. Paolo is full professor in philosophy of law, department of law, political, economic, and social sciences. He has a lot of activity that carried out in the years of his career. And I know Paolo, just because he has specific expertise in aesthetical law and in a spatial approach to the relationship between the visual dimension and the production of meaning through the law or legal experience and the law's existence. So I don't know what's the time, so I give the floor immediately to Paolo. Please, Paolo, start.
Okay, thank you so much. I hope you could see my presentation. Thank you for, you could see my presentation?
Yes, perfectly, Paolo.
Okay, perfect. Thank you so much for a very interesting presentation. I would like to make some to give some contribution to and also pose some question within my presentation to the other. I found it very interesting. What I would like to do with you is speak about the philosophy screen and interpretation of Plato's cave. But obviously is a topic in which I'm working on, and I would like to say something about several points. That is receptio moribus, an interpretation of a Roman Roman law scholar, Filippo Gallo, very important in Italy, concerning legal interpretation and customs. And then very shortly say something about public opinion. And then what is legal emblematic by Peter Goodrich and Pierre Legendre. And also the vision of the normativity of the image of Pierre Legendre. And in this context of legal aesthetics and legal emblematics, try to say something about the interpretation of Plato's case, starting from Philosophy Screens book by Mauro Carbone, starting from Deleuze and Merleau-Ponty. And finally say something about the attempt to think Turness as aesthetic Turness as a norm screen theory related to the problem of the darkness after law. So very shortly, the starting point is Filippo Gallo theory of revolutionary theory of Roman law against legal positivism in Roman law, and from the idea that the legal interpretation and customs are very close, are problem connected in Roman law. And this is the idea of receptio moribus, the idea that the interpretation of a jury consult is not the starting point of the law, but we need also of something that is acceptation in the social legal environment, receptio moribus. And this is the very important point. Obviously, is not the possible follow-up of this idea of the new interpretation of a Roman lawyer. But it's very important to say that interpretatio creates law only through the reception by the social environment of the interpretation. And what I would like to say is the fact that it's very important also this point for understand what is interpretation theory now in our society. And so what Filippo Gallo proposes is a sort of counter-revolution, starting from the law as a artificiality. Both of you spoke about fiction in law, in literature, law and literature, and in robotics also. So I think it's very close to this point that is for me very interesting, because the main expression of the ars juris are the position of general and abstract norms, the solution of decision of cases and doctrinal elaboration. But is this for Filippo Gallo a false ideological vision of legum doctrina from Justinian, still dominant today, that the general and abstract norms summarized in the law are placed above everything else in law? So the view of the ars, the receptio moribus, the customs, imposes a radical reversal in adherence to the purpose of law and human needs. And so it is the counter-revolution of receptio moribus against legum permutatio by Justinian. So this is a starting point for understand what is darkness after law, interpretation and customs. And the idea that the space opened up by the interpretation of law represents something that comes after the law. Attempts to ask the positivist, obviously, notion, not realist one, and so on, of law. Attempts to construct a theory of the interpretation of the norm, move in the direction of the constructing a clarity. It has a lack of darkness in the law. So second point, very, very, very short, in public opinion in constitutional law. I think that receptio moribus in Roman law could be interpreted as the manifestation of a popular sovereignty. But the problem is that this kind of sovereignty becomes sovereignty, obviously, visible through the class of jurists. Through what we could define a sort of elitist power. So the problem of the constitutional theory of the separation of power and the idea of the media as institution is the fact that public opinion in our constitutional system are invisible countervailing power that intervenes in a negative form by limiting the expression of any positive power through the truth of revolution. Symmetrical to the election as a form of delegation of power or sovereignty. So the forms of manifestation of this power of the people is negative and operates as a form of persuasion and fear toward rulers and judges in our constitutional theory. So the third point is something that is inside legal aesthetics and is related to the representation of an emblems of Witter by Goodrich in the books of Peter Goodrich on legal emblems. In the image, we see the sovereign crowned and with a scepter or office in his left hand, standing upon the globe, with a reference with Kantorowicz's work, obviously, in history. What I would like to point up is the fact that the Kate of this picture is the eye in the sovereign's chest, you could see. And this, for Goodrich, here is wisdom exemplified and embodied as the very heart of sovereignty, expressed as an interior eye. The sovereign, like justice, has no need of bodily eyes of an exterior vision. What matters is the unwritten law, the reason of nature that is carried inside and seen by the eye of the spirit, as it looks in before it emanates outward. So we could say that wisdom precedes vision and knowledge comes before sight. We have, in short, for Goodrich, to learn how to see and make sense of the external world. This is the political theology of the image as we inherit it and manipulate in law, till to the robots and the robot's eyes and computer vision. So this point is the neologism that Goodrich invented, the obiter dicta, sorry, as a sort of iconic version of obiter dicta, with reference to the ratio decidendi, that is learning how to view law as well as to read it, related to the tradition of legal emblems and inside law. So, as the obiter dictum in the argot of law is something that is said along the way to the decision. This is part of the reasoning of the judgment, but not of the reason, not the ratio decidendi. The obiter dicta are things seen along the path to judgment. I think it's related to the problem of the shadow, of the darkness of the law, and the relationship with images. And so it's to address obiter dicta is to acknowledge the importance of justice being seen to be done, also with reference to penal law, obviously. And so I think that following Goodrich, that the concept of obiter dicta is intended as a significant and topical addition to the method and interpretation of contemporary law. And Planet Hollywood and multimedia digital videosphere have collided with the dead end of the law in this idea. And it is necessary as never before today to study, appreciate, and account for the elements of ceremony and visibility, the staging and enactment of legality of obiter dicta. And so we could pass to philosophy from law, from legal emblems, with a representation of Plato's cave in philosophy screen, book about phenomenologist Mauro Carbone. And the idea of Carbone that the allegory of the cave is something that for philosophy always made its state for screens quite clear, regardless of the kind. And I think for law is something very similar, starting from Plato's, obviously. For Carbone, one could even claim that philosophy traditionally identified itself in a fight against the screens, which it assimilated with the illusion, the deceit, the obstacle, preventing from the contemplation of truth. In fact, when Plato describes in the allegory of the cave, is not a single screen, but two screens. One showing, the other one concealing, both conversing, however, in their global effect as two complementary possibility of one single configuration. I would like to call, from the point of view of legal aesthetics and philosophy of law, the fairness of the normal screens. This is the point on which I'm working on from a perspective of legal aesthetics. So this idea is is not related to law, but to the philosophy, and for Carbone is the archiscreen. you could see in the allegory of the cave, Plato talks about what is translated often as the opposite wall, which works like a screen meant a surface for showing images. Since it is precisely on this surface that the cave's prisoner see the shadows of the object carried by man behind them. You could see. Plato alludes just twice to the wall, to this wall. The second time he imagines that it echoes the human voices sounding into the cave, as if they came directly from the shadows. It is the only allusion to a way in which this wall could indirectly contribute to producing greater than simply reproducing the illusion of images that are supposed to be sensible reality itself. The wall we are speaking of is opposite to another one, which Plato calls a teikion, a word meaning a low wall built along a road. The cave's teikion has the purpose of concealing the people carrying the various objects that rise above the low wall, similar to what usually happens with puppeteers. In fact, according to Plato's account, the teikion works as a paraphragma, a word often meaning a protective structure like a parapet or a bulwark, from behind which the puppeteers exhibit the puppets to the audience. Indeed, this word has the same root as the verb frasso, whose general meaning is to fence in, to edge round, hence with collateral notion of defense, secure, fortify. And the word screen in Italian maintain this ambiguity, this shadow. And I think it's very important to understand the screen norm, what is a norm. And a norm is at the same time something that show and that conceal. So the meaning.
5 minutes left, Paolo.
Okay, thank you. So this is the very important point of this theory. I would like to state that in this allegory of the cave, Plato presents the two fundamental possibilities of this arc screen. The screen as concealing surface and the screen as a showing surface. Neither of which can be merely opposed or separated from the other, either logical of history. A negative screen and a positive screen, even if considered autonomously from one another, are portions delimited from the surrounding space, thus founding a peculiar relationship with it, as well as the possibility of the third pole. In the case of vision, this relationship is usually characterized as a mutual relationship between foreground and background. As the Gestalt theory has pointed out, such a relationship reciprocally constitutes one as the visible of the other. And it also founds a point of view as its third pole. And I think it's related to the legal concept of thirdness, this third pole, this arc screen. Very shortly, I studied the point in other papers. For Carbone, but also for Legendre, the Italian perspective, the history of Italian perspective, Piero della Francesca, Alberti, image the windows as an apparatus dispositive undertaken by the epoch we call modern, as the model of our way of seeing the world. The way of seeing the world that is still considered as dominant in the Western tradition, still to Planet Hollywood, is one that was first formulated by Leon Battista Alberti with the De Pictura, the window, very famous. First, I trace a quadrangle as I wish, which right angles on the surface to be painted. In this place, the rectangular quadrangle certainly function for me as an open windows through which the historia is observed. And this is the version, Italian perspective version of the relecture of the Plato's caves. And I think the thirdest we could find both in Legendre's work and Carbone reading of Plato's cave as the convergence of the all the line in linear perspective. That is to say, the technique in which all the straight lines that are perpendicular to the plane of the painting converge toward a single vanishing point that is represented as an eye, the same eye of the political theology of the image, which are speaking Goodrich. So I have no time to understand the way in which the image is normative, but in the analysis of Piero flagellation of by Legendre, we could see that for Legendre, the painting is like a norm, and the hermeneutics of a painting is the fact that the window frames as a turnus between the painter viewpoints and the gaze of the viewer. So we have the same way in which the norms operates in our society. So we could end saying that the turnus is something that is common to the Italian invention of perspective, and the idea of the archiscrive of Marco Carbone speaking about. And so this is the definition of turnus, the logic of the turnus for Legendre by Peter Goodrich. The third of the absolute other, the image, the emblem, the mirror of text as the foundation of law. And I think that my thesis is that the legal emblematic turnus is a sort of Vision theory of legal archiscreen, as the point of in which I is the representation of the foundation of the law, in which the history of the dark cube from Alberti's perspective to Hollywood, showed by the photography of a film by Sugimoto, is conveyed to modernity through the Italian perspective by Alberti and Vico images and theory of scienza nuova that you could find in the image. And then I joined after for Mirzia after hearing the presentation, also maybe till to the dark side of the Pentland social physics data-driven society and the image of the iRobot with television that Fluxus artist Nam June Paik showed it to us in 80s. So this is the idea that the darkness of the law, the darkness after law, is related possibility to understand an interpretation in which Plato's cave reading by Carbone is related to the legal emblematics by Goodrich and Pierre Legendre. So this is the point in which I'm working on.
Thank you, Paolo. Thank you so much for the thoughtful and multidisciplinary presentation that showed us the maybe law and its significance is lying in the quasi-diaphragm between the visible and the invisible. The question is, when and how are we able to mine this dimension of quasi-visibility, that in which, in this boiling dimension, the Kantian transcendental schematism or the Persian iconism, in a sense, dwells. It is very difficult to define the situation from which the visible law took its form and at the same time was concealing the invisible that made it. Okay, thank you so much for this presentation again. And so I pass to the next speaker, who is Daniele Anselmo. His presentation is titled Defective Law. Daniele is professor of philosophy of law at LUMSA. He's author of Sharia and Diritti Umani and Fedi, Bioetica e Diritto and Lessico della Libertà, published and edited with other authors. And so I immediately passed to the presentation, and so I'm giving the floor to Daniele, and I invite him to start, please.
Thank you so much, Mario, and I will begin immediately. I will begin by admitting that my conception about law can be defined as skeptical. I do not believe that law gives answer, and particularly right answer, even if it claims to do it. It is a way to lead the human actions to avoid conflict as much as possible, but not all conflict can be solved by legal instruments, even if nowadays law is supposed to be the solution of them. This contribution arises from a reflection on the field, starting from a privileged point of view, one that is both professional and academic. The relationship with the customer on the one hand and with the first-year law student on the other made me think about law from a popular conception of it, made up an intuition rather than true knowledge and lacking institutional preconceptions. This empirical approach, characterized by a succession of question and answer with people who most of the time have only a faint idea of what law is, but have a much sharper perception about what they expect from law, made me share some comments on the subject. I apologize in advance for the lack of systematic nature of this embryonic work, which is mainly due to the indeterminacy of the idea of law that I have found and the impossibility of effectively synthesizing what has been noted in this first survey. Although the 19th century paradigm of legal positivism, of the supremacy of the law and of the completeness of the legal system has been overcome, the trust placed by the people and above all by politicians and law does not seem to have been passed by, seen as a panacea for all ills and a solution to all problems. Even the most relevant voices of 20th century juridical skepticism have never abdicated to conviction that a rule, even though outside of state law, might still be found and would therefore fill the gaps in the state law. I'm referring to the major exponent of the free law movement, from Ehrlich to Janin and Kantorowicz, who supported the presence within the system of extra-legal norms coming from social life and from judges that could have flanked the legal order in order to fill the gaps of the system. The mistrust in the completeness of state law and in law as its icon was never gone as far as a radical critique of legal system. There has been an attempt to give more space to the judicial decision because it is more immediate and therefore more responsive to the needs of the agents. But in any case, the rule of law as the supreme and last foothold to solve any problem has never been questioned. Today's contribution wants instead to support the status according to which, in spite of what the law appears or is supposed to appear, law cannot be considered the right or ideal way to define every issue, if only for the fact that it regulates the relationship between subjects, treating them as strangers even if they are not strangers. It seems to me that nowadays law is presented and perceived as a means able to solve most of the problems affecting human relations as a necessary and indispensable element of social life. This idea is mainly convened by politicians, which in the absence of adequate responses to the demands that come from below, put most of the expectation of his electorates on law. Finally, the current crisis of intermediate institutions, such as the family, the dematerialization of relationships, increasingly lived at a distance, and the general distancing from religion, meant not in specific sense of adherence to a religion, but in a general sense that a question about finitude, have exacerbated this drift. In this perspective, what I find deeply interesting is the identification between law and justice, which, beyond naturalistic theorizing, represent a common feeling about law. If a class of first-year law students is asked, as I have done, to say without thinking what law is, more than half of them will answer justice, proving that when common people refer to law, they actually ask for justice. This happens in two paradigmatic cases: when recourse is made to a court, or more generally to a judge, or when, even within a common sense discourse, a right is claimed with phrases such "I have a right" or "you have a right." Most of the time, the one who's speaking is not an expert in law, but with this kind of this, he wants to claim something that he thinks right to be done a certain way. I realize that perhaps this view may be partial and susceptible to critics, but it is, in my opinion, a good starting point. If law is made for human beings and regulates their actions, it is possible to disregard what they think law is. I start from the bottom because it is from the bottom that that is from the people that come this request for law, although it would be more correct to say justice. Law for people is invoked most of the time only in the pathological moment of the relationship between people or between people and things. Better, law regulates social relationship, but it is all invoked when the latter is transgressed or is thought to have been transgressed. It appears necessary only when we feel that something is missing, and therefore we seek to re-establish a balance that we feel has been violated. This empirical conception of law leads us to ask ourselves, first of all, whether we should turn to law and whether we should do it today in a certain way. One of the first answers is that law presents itself, today more than here, as the instrument able to solve in general terms every problem concerning men and their mutual relations. In a society such as the present one, characterized on the one hand by a strong cultural pluralism and on the other by a deep crisis of traditional institutions, which had the task of mediating between the individual and the state, the law plays the role of regulator of human action and peacemaker of possible conflicts. It, in fact, has been relocates the relationship between subjects on the basis of equality, treating them as strangers, even when they are not strangers. What appears to the jurist as the point of arrival of an admirable architecture cannot, however, be fully understood by the common man. The fact that equality implies a mutual non-involvement between legal subjects seems almost a paradox. Since it is true that all human beings are equal before the law, it is also true that they are different and their relationships are different. sometimes characterized by affects or ties that cannot but be considered as relevant. This depersonalization of relationship in the name of law has led, on the one hand, to a strengthening of the role of law within society, with the consequent affirmation of law as the sole and undisputed sovereign of social relationship. Law is a new golem. It substances itself with its own rules to acquire more and more power while waiting for someone to stop it. This golem adopts a method not dissimilar from the divide et impera put in play by Caesars. It acquires more and more strength, and more credit-making people believe it is indispensable, more than it really is. Men find themselves unconsciously acting following the path traced by law, since most of the actions are regulated by it. If we think about it, even the act of walking down the street is regulated by legal provisions, such as those the highway code, and even feelings are subjected to legal regulation, and if not their own, at least their external manifestation are, as in the case of marriage. This recourse to law, understood from the objective point of view, is also the result of the diffusion of subjective rights, of the exasperating search for affirmation and self-assertion of the individual through them, and of the voluntary or involuntary camouflage of one's own interest as rights. The just bucks exhausting propaganda perpetrated for years in the name of human rights has led to an advanced sunset of the age of rights, and unfortunately to a weakening of those rights, which are increasingly limited in concrete terms by the contrast with other rights. In this context, the individual seems incapable of placing himself, of properly realizing his own position in society. He's unable
5 minutes
to
left. 5 minutes left, Daniele.
Okay, see, thank you. Unable to fully master the norm provided by law, by flutes them as a threat again those who, according to him, want to go against his interest, his expectation, etc. This does not mean that all law and all rights are not available to him. This does not mean that all law and all right are brandished as hatches of war, but that very often those who speak about it, assuming as a fact that they possess a right, in reality not only do not possess any, but claim a sort of summary justice modeled around their own person. This happens in many cases, in many areas of law, but mainly in family law, inheritance, and criminal law. The jurist then has the task of clarifying, of questioning himself about the real structural possibilities of juridical experience as juridical, so as not to remain below them, but also not to aim at what is precluded to him. It is a serious omission not to ask a law everything that can be obtained by law, but it can be ruinous and is in any case illusory to claim to obtain by law what it cannot give. For this reason, we can begin to question ourselves about the type of man who today appears to be protagonist of the history, and homo juridicus unbalanced toward a total trust in law, seen as the only instrument capable of giving what is desired. Since ancient times, the relationship between man and law has been ambivalent, oscillating between pessimism and anthropological optimism, between an idea of man incapable of overcoming his own brutality and that of a man who instead has no need of law. Through the philosopher of natural law, we have been accustomed to think that man can overcome the brutality of the state of matter, characterized by the formula homo homini lupus, and experience a form of coexistence based on law. The law is therefore seen as a tool to allow human beings to live together, even their being imperfect but perfectible. This approach, however, does not prevent the growth of man and especially his desire to become better. However, in the contemporary world, we arrive at the paradox that the use of law fully prevents the divinization of the human being, that in other words, it prevents the ethical elevation of man, which the more optimistic forms were aiming at an elevation that produces the abandoning of judicial forms. In other words, man, in order to get out of the state of nature in which he is substantially devoid of rules and in which relationships are regulated by force, needs law, which instead guides his behavior and his action. But if man needs law and only law, he is no longer able to tend towards that higher stage of knowledge, which should lead him toward divinity, that is, to raise his own degree of ethics to such a level as to longer need. Troppo tempo? Stop? Okay.
Yeah,
Okay.
Your time is gone.
Okay, bye.
Okay, thank you. Thank you. Thank you very much for this skeptical but not so pessimistic gaze of law.
Yes,
So we pass immediately to the next speaker. She is Silvia Zorzetto. Her presentation is titled Darkness and Clarity in the Legal Domain, the Nightmare and the Noble Dream. Silvia is Associate Professor in Philosophy of Law at the University of Milan, and she is habilitated as Professor of the first ranking. She is author of several volumes, among which the reasonableness of private individuals in Italian language, La ragionevolezza dei privati, La norma speciale, the special norm, and Repetita iuvant. So I know was her time, so I immediately give her the floor. Please, could you start?
Thank you, Mario. Good evening, everybody. First of all, thank you to the organizers of this conference and this panel in particular. I'm sincerely pleased to meet again dear friends and to meet new colleagues from whose presentations I have learned a lot. My special thanks to Marika, who created this panel and thus had the merit and the patience to coordinate everything. I apologize in advance to all of you and everyone involved for my talk, which I hope will not be too confusing. The subject of my talk is clarity or obscurity of legal language. I use the English word obscurity instead of darkness, as the latter has a special connotation, tending to the most extreme opposite of light. This lexical notation is useful because it provides a way to specify that clarity and obscurity are relational concepts that involve a degree. I learned from the analysis of the concept of Karl Hempel, which is still illuminating this respect. Nothing is clear or obscure in vacuo or in abstracto. Both clarity and obscurity are concepts that can be ordered and indeed always imply, albeit implicitly, a relation and a hierarchy in the sense of more or less. There is a continuous spectrum of hypotheses, like a straight line consisting of an infinite number of points, potentially tending towards more or less infinity, absolute clarity and absolute obscurity or darkness, just like the spectrum of light. In this case, the physical metaphor also gives a fairly faithful representation of how language works. A rainbow is an example of a continuous spectrum. Here the colors represented are in the visible spectrum between 380 and 760 nanometers. Light in this wavelength range is visible to the eye, unlike the visible spectrum, light with different wavelength is not visible. The electromagnetic spectrum is an example of a continuous spectrum that goes beyond our empirical sense of sight. Metaphorically speaking, language, like physical light, also have a dark or opaque component that is in no way detrimental to its function or the effectiveness of communication. It is a latent resource, and as such, it can be used well or poorly abused by its users. My approach, as it could be understood, is to analyze legal language with particular attention to what is called high or macropragmatics and low or micropragmatics. Obviously, the distinction is only a tool of conceptual analysis. In the reality of linguistic communication, there is no clear division between macro and micropragmatics, and to avoid any misunderstanding, the high-low pragmatic pair had no evaluating meaning or positive connotation. It simply refers to attention to the general goals of communication in the legal domain, the general functions of legal discourses, and on one side, and to the individual discursive circumstances that arise in particular cases. However, I will try to deal with the use of clarity or obscurity of legal language in a concrete way, using some examples from practice. As it is a very broad topic, I can, of course, only be very selective. I will therefore give a few examples from legislation and case law, Italian and basically, which of course do not claim to be exhaustive, but which are nevertheless paradigmatic, or at least some orientations and phenomena. Our panel proposal focuses on darkness as a consequence of law and the appearance of legal word on the public discursive stage. The aim is to explore from a multidisciplinary perspective what makes the light of law invisible. That is the umbre, to use an interesting expression from Majorica, that authoritative formulation casts on social experience, and what crosses the semantic boundaries of what is included in legal categorization and what is excluded as their opposite. As everyone knows, this attention to obscurity is deliberatively provocative, taking exception to the most widely held view that enjoys the greatest general favor from both authoritative or institutional and academic perspective. It is counterintuitive to say at least that the obscurity of law is now seen as a value or an ideal. According to the explicit statement, it is not said, and it is quite possible, that the reality behind the general favor for clarity is not so largely genuine. Even assuming that there is indeed a general inclination and favor for clarity, the fact is that from a linguistic point of view, clarity is one of the most controversial and undefined terms of our time. Indeed, the very technique of definition in this regard is paradoxically unclear and yet not shared. So much so that the notion of clarity or the clarity-obscurity pair of notion is often explained by reference to a long list of our notions such as vagueness, indeterminacy, ambiguity, prolixity, brevity, efficiency, happiness in the linguistic terms, of course, and so on, all of which are highly complex. Importantly, it is nevertheless possible to speak of clarity and darkness only on the basis of a particular theory of language and assumed meaning. Hence, the difficulty of clarifying the notion of clarity, pardon the verbiage, in the face of the different literature and semiotics that law often fail to bring to light. On one hand, then it is a truism. On the other hand, it is a constant challenge to face that the fact that the concept of clarity itself is anything but clear. Clarity, as the other side of the coin, also brings with it obscurity. In this context, it is worth recalling, for example, a maxim of Cicero in the Invenzione, according to which ex ambiguo autem nascitur controversia, conquid senserit scriptor obscurum est, quod scriptum duam plures res significat. I refrain from an exegesis or even a historical reconstruction of this maxim and leave the matter to the historians of law who have studied the principle in claris non fit interpretation very intensively and have attempted to go back to its first manifestation or antecedents. The history of these Latin maxims, however, is philosophically instructive because it shows how the clearness and darkness, or clarity and obscurity, is something innate, we could say, to legal language and its practice. Today, clarity is highly valued by legal scholars, judges, legislators in both the civil and common law legal tradition. Among the many emblematic examples are the US Plain Writing Act and the Clear Writing Campaign of the European Commission, and all its more recent ramifications, such as the European Better Regulation Toolbox or the Smart Regulation initiatives that are devoted to improve the quality of jurisprudence. The quest for clarity is one of the leitmotifs of thinking about law through the centuries, and this quest goes back centuries, as the maxim in claris non fit interpretatio and all its prominent versions show. Similarly, the notion of clarity of meaning, usually explained by reference to clarity and considered close to plain meaning, runs through the centuries, from the early debate on the so-called legalese in the 60th centuries to that which flourished in the second world decades of the 90th, then the plain English movement. Inspired by legal history and contemporary semiotic, a general approach in favor of clarity is a kind of creed or ideal and is increasingly advocated in legal theory and practice. More rarely, it is under debate whether this mainstream is genuine or naive and to what extent it fits the laws as it is rather than it ought to be. We may ask whether the frequent claims in favor of clarity made by politicians and autocratic apparatuses are much more likely to be a cover rather than a genuine ideal of transparent policy, to be crucial. Many uses of clarity turn out to be purely symbolic and politically oriented. To claim that something is clear can be a definitional stop frequently, or a way to prevent counter-arguments in public reasoning. Clarity is invoked in public debate to cast a legal matter and reform, or whatever kind, in a better and more attractive light to create more consensus. The fact that the appeal to clarity runs the risk of being misused and instead conceals a systematically spreading opacity should not, however, lead to the mad consequence of throwing out the baby with the bathwater, to take up a well-known metaphor. Clarity of discourse is an expression and consequence of clarity of thought, and without it, law cannot exist. As the 20th century lawyer argued forcefully, I remember Vittorio Scialoia, since there is no legal thinking except when it is clear, everything that is unclear may belong to other sciences, but not to law. and therefore lawyers must write their books in a language that can be understood. Now, to say otherwise sounds absurd and would be universally disapproved, probably, but the fact and also the necessity of this positive statement are on a pragmatic level a proof that the practice does not go in the direction indicated. From this point of view, then the question arises whether the increase in appeals and declarations in favor of clarity are not an indication of a growing general darkness and thus a kind of reaction. On the other hand, as Shaloya's claim shows, it is very difficult and even impossible from the point of view of empirical and semiotic researches to make accurate and reliable intertemporal comparisons of whether legal clarity is greater or less today than at any time in the past. The only reliable analysis in this regard can be done at a micro-pragmatic level, taking into account some very limited context and assuming the identification of common measurements parameters, which is, of course, extremely difficult because the clarity and darkness ratio is not objective and cannot be determined by objective parameters. Another famous instructive quotation is found in Pietro Calamandrei in the Elegy for a Judge written by jurists. Brevity and clearness, when they come together, are the sure means of bribing the judge honestly. This is, as well known, an oxymoron that highlights the contrary tendencies of legal experts, being they judges, lawyers, or academics. As Federico Bambi has recalled in important studies on the clarity of legal language, Calamandrei was one of the greatest jurists who disapproved of how the language of law in all registers can be verbose, prolix, unintelligible, or better, intelligible only to initiated. There are many causes and reasons why this happens. Three main reasons can be those, the following: linguistic ignorance or lack of knowledge of the language by the users, which is not at all surprising, since it's typical of the language to be used without knowing how. Opportunism, in the sense that deliberate pursuit of opacity or obscurity for future motives. Third, aesthetics or hyper-technicalities, starting from a distorted conception of legal language as something abstruse, or so to speak, elitist, as a language only for clerics.
Silvia, 5 minutes left. 5 minutes left.
Yes, thank you, Mario. Fine. We could make many examples from Italian attitude towards clarity in the legal field, and Italian legislator adopted the principle of clarity as a general principle, for example, in the administrative jurisdiction. I remember Article 3 of the Administrative Procedure Code, and from this administrative jurisdiction, the principle has been extended to civil jurisdiction, and the Court of Cassation consider it as a general principle of law. Many are the initiative also of the National Bar Council, and nowadays ministerial committees are very busy evaluating possible reforms and regulating the procedural consequences of the violation of this principle. More generally, the Italian Supreme Court has stated that this general principle is a general principle of procedural law, and the lack of clarity is contrary to the principle of reasonable procedural length. And so contrary to Constitution. In this regard, there are lots of decisions that consider inadmissible appeals for lack of clarity, and also the clarity is considered by the Italian Constitutional Court as a parameter for the admissibility of issue of constitutionality. This mainstream is also widespread in the EU law, and in some way results from some EU legal trends. I can remember above all the actor Clare rule that was initiated by the Circuit case by the European Court of Justice. Another overwhelming example regards authentic interpretation, which is a remarkable case that deserves attention because according to the settled case law, the rules of authentic interpretation are authentical and different from the rules that innovate because they express that something that is already prescribed from the beginning, they have the objective aim of clarifying the meaning of existing rules. And it should be remembered that this is precisely the belief that authentic interpretation does nothing more than reiterate the previously enacted law, and this legitimizes its retroactive application, and thus saves it from constitutional illegitimacy. As many studies have shown, this conception of authentic interpretation is not a theory but a doctrine or an ideology, in the sense that it serves to legitimize and justify the validity of legal rules regardless the validity of the semiotic category to which they refer. I skip many other examples that arise from the contract law, the application of the in claris not interpretatio principle, and also its history as remembered by Gino Golla and among many others jurists. To conclude very quickly and not to waste time and leave the floor to Marjorica, which is our guide in this panel. I just want to say last a very brief conclusion. So the a basic alternative that we have when we speak about clarity and obscurity in legal language is that in legal interpretation there is ever the possibility of erroneous recognition of absurdity, false positive, and conversely erroneous non-recognition of absurdity, false negative. And this is a pragmatic variable that explains the actual use of plain language by courts. Above this, behind these questions lies a fundamental alternative about the nature of legal language. This is a choice between a legal semantics that is directly accessible to everyone, the Enlightenment model or the Clapham omnibus model, and the legal semantic that is administered by lawyers in a sort of oligarchic model. In my view, this second model is the one most often adopted by contemporary legal systems, but this does not mean that the plain meaning, which is relevant to law, must always be different from the ordinary meaning. On the contrary, in such oligarchic model, the autonomy of legal semantics from ordinary language is more a matter of degree and is often determined by the interplay of lawyers and everyone which is part of legal practice. Thank you for your attention.
Thank you very much, Silvia. Thank you very much for the presentation. Your approach has, if I if I may, an infralinguistic post-Manichaean approach to our main topic, carried out between historical analysis and analytical approach to the philosophy of law and language. Thank you sincerely. Thank you. Now I have to pass to myself, and last and least. And so let me give the title of my presentation directly, because I can't say anything about myself. So my presentation is titled "The Shadow Legal Word, the Phrastic in Law and its Semiotic Accidents." So I'd like to start by saying that legal rules prescribe behavioral patterns. In so doing, however, rules establish not only how the world should be, but also what it is. When a category is included in the descriptive or phrastic part of legal statements, it implicitly casts a shadow on all that does not fit into it. The light of law, as it were, throws into darkness what is left out of the semantic borders of legal words and related categories. It creates its own umbra. This umbra is the very problem, I think, of the darkness after law. That is our main topics. This operation, the casting of the umbra, however, fails to provide law with a complete self-referentiality. Categorical spectra, porous semantic borders are not affected by an inherent semiotic exceedance. What populates these areas of exceedance is endowed with semantic and axiological relevance in respect of the above categorical frames and the axiotelic, axiological, teleological standards according to which they have been previously drawn. This makes it so that as soon as the legal statements are enacted, they inactively start to work against their consistency with the same values and ends they embody. Nonetheless, the semiotic exceedance is more often than not thoroughly silenced. In a sense, darkness after law seems that to be another name for both the quest for legal certainty and, on the other side, injustice. I think that the overall issue has to do with an ideological, if not epistemic, approach in conceiving legal experience in the production of law. Modern legal experience left behind, at least allegedly, the assumption that human law should align with the transcendent existentialized collection of paradigms embodying the moods in a Spinozian sense of justice. In the same vein, the divine source of natural law and its categories began from the dawn of modernity onwards a discharged axiomatic hypothesis. Nonetheless, the idea of a logical hierarchy extant within the mainstays of legitimation of law's authority and ongoing legal experience remains in the onset of the modern jural imagination. The salience of this resilience coincides with the inevitably heavier emphasis put on the chronological foundation of this hierarchy rather than on its logical and ontological one. The modern lawyer's gaze, especially if cast from a positivist perspective, the legitimacy of law in its very existence presupposes a kind of chronological and thereby discursive break from the process of axiological and semantic discernment previous to the institutional birth of the legal as such. The myth of the social contract includes in its narrative the drawing of this chronological boundary line. What is often overlooked is that the simultaneously prognostic and deontic projection of the social contract also necessarily involve a semantic social contract that reaches far beyond the political significance of what the usually intended by it. The grasp of the future, which is inherent in the same idea of the social contract and the possibilities of its fulfillment, cannot come about without the permanency through time of the semantic categories relating to the social and empirical phenomena, and as such unavoidably included in the descriptive or phrastic part of any legal provision. But this is precisely when facing this prerequisite, which ends up at a kind of crossroads, that modern legal thought seems to collapse by falling in the paralogical circle. Insofar as the above semantic stability shows itself as an inescapable prerequisite to legal effectiveness, it transmutes in an apodictic feature, denoting the law in and of itself. The main consequence of this epistemic but also psychopolitical attitude is that the lawyer's approach to the present and the future shows up as if they turn their backs on this time experiential dimension, while on the other side, looking at their phenomenal content reflected in a mirror. This mirror, unfortunately, is the collection of past categories, the same ones included and stiffened, with the seal of the authority inside the semantic social contract imagined as coextensive to the original delivery of law as an institution. Typical quasi-axiomatic tenet stems from this epistemic imagery, the maxim according to which law makes its facts. Categorical stability cannot be assured and maintained through authority. This is the problem. I think that the main problem of positivism. And it is a prerequisite of both the effectiveness and the very existence of legal system. The direct inference is the law is unable to ensure its own preconditions. On the other hand, some doubts arise about whether the main and genuine significance of our legal enterprise coincides with the attempt to make the future anything but a replication of the past. In facing this epistemic uncertainty, in a sense, a meta-uncertainty, I think that it would be helpful to probe the anthropological and cognitive function of categories, be they axiological or empirical. So the above conclusion, I think that leads us to consider that categories cannot be intended as dies or molds made to forge exact copies of past experience or experiential situations. They are only tools to support the organisms in the enaction of intelligent and as adapted as possible responses to the challenges posed by the environment. In their inherent projection toward the future, categories imply a certain degree of semiotic entropy, which is the other side of their adaptive efficaciousness. Without such a weighted entropy, they would fail in the accomplishment of their function. That is, their involvement in the organism response to the novel and unusual environmental conditions would then have been adaptively dysfunctional. From this point of view, it could be observed that the lack of semiotic entropy would impinge on their authentic signification and their inherent purpose. As paradoxical as it may appear, the ossification of a categorical morphological structure, namely the exclusion of any degree of semiotic entropy in the experiential implementation of pre-acquired schemes, would produce inauthentic copies of the original experience from which they stemmed, or that at certain time span they efficaciously supported. But if the morphological stiffening of categories makes them not adaptive, this means that the lack of semiotic entropy can produce the same kind of uncertainty and prognostic failure that is both designed to avert. The epistemic mistake nestled in the meta-narrative of legal positivism is rooted, oddly enough, in the socio-historical assumption that undergird and justify its rise in modern imagery and institutional experience. The early positivists argued that law had a systemic conceptual structure assessed allegedly isomorphic to the fabric of social relationships. The fidelity of the pertinence constraints coextensive with the categorical conceptual structure of positive legal language should assure the correspondence between the interpretation and implementation of law's provisions and the spirit of people or the will of the people. This kind of correspondence, however, could be assumed only by ingraining it in an at least a relatively steady social and cultural context. Consequently, as long as a legal rule remained in effect, its correspondence to the social environment could and should be taken for granted. The same argument will also apply to the categories included in the legal provision, regardless of whether they pertain to the prescriptive, gnostic, or the descriptive, phrastic parts of legal enunciation. The main difficulty embedded in the above thesis of semantic social correspondence has to do with the ambition of law and lawmakers to enact rules capable of grasping the future. And besides, a legal rule inherently affected by imminent obsolescence would make little sense and would transform the lawmaker's mission in a frustrating and failing enterprise. Law must last, at least for a reasonable amount of time. Otherwise, its own deontic significance vanishes. This is even more true for constitutional provisions and principles, which self-qualify as constitutive elements of all future developments of state and society. Exactly as for categories and categorization, if analyzed from a general cognitive perspective, law too must reinsert a certain degree of semantic and operative entropy if it is to come to terms with the unavoidable unpredictability of experience and specifically social change. Law 2. Legal language, therefore, must include in itself semantic change. But the acceptance of this constraint, needless to say, strikes at very heart the thesis of semantic social correspondence lying in the backdrop of legal modern imagery, and more specifically in the positivistic approach. The last consideration, allows me to return to the psychosocial caesure the modern legal thought places at the very moment of the institutionalization of law, and more specifically with the alleged sealing effect of the semantic social contract silently commingled with the political one. The idea of a semantic social correspondence owes its argumentative strength and plausibility only to the assumption that legal language and at least the structure of social relations in fact mirror each other in a reciprocally referential and abiding way. Otherwise, the permanence of legal rules and their enunciations would necessarily imply a continuous renegotiation of the original semantic social contract, and thereby the categorical boundaries related to the terms included in the legal enunciations. On the other hand, such a renegotiation would implicitly debunk the assumption of a referential correlation between legal words and social facts, liable to be understood in conceptual terms, and therefore declinable as a result of an analytical interpretation. Even if adapted to the specific exigencies of the deontic language, the possibility to apply a truth-value logic to the referential relation between legal terms and legally relevant social facts would prove to be inviable. The adaptation between the categories of legal discourse of inside and the categories pertaining to the natural language on other specialistic ones, but not legal, related to the social and empirical facts should inevitably involve axiological and teleological attitudes. But this would imply that in the construction of juridical syllogism, the medium term should be the result of an open work translation necessarily steered by axio-teleological and even aesthetic criteria. In this way, however, the entire theoretical edifice of positivism and moral legal imagery would collapse. Hence, the resorting to the traditional argument of the distinction between hots and these, and the deontic and empirical, and the assumption for which law makes its fact because as long as it is valid and formally efficacious, it is legitimized to mold its factual world according to its own axiological deontic perspective. The tragic implication of this defensive way of thinking is that the authority of law has transformed itself into power, and the allegedly legitimized lawless blindness to the semantics of facts has allowed them to conflate what is to be and what is. As I tried to emphasize above, categories and their semantic structure are not isomorphic copies of reality. On the contrary, they are tools involved and functionalized in the production of experience and its adaptive orientation. For this very reason, their responsivity to changes in the environmental conditions, and then their opens to the semiotic plasticity, is a feature constitutive of their authentic original meaning. There is no categorical assumption or declination that does not include this mean-sense dialectic, and therefore an axiological teleological factor at work in the construction of its semantic structure. When lawyers discuss invokes their entitlement to describe facts, including their empirical aspect from their own exclusively legal perspective, they do nothing different from what common people do when they mold the categories of natural language. The final effect is that law, even by force of the practical effects resulting from its implementation, ends up imposing not only what should be done, but then surreptitiously also what is. Unfortunately, this is the outcome of an axiologically, teleologically driven selection among the elements of the phenomenal world. But those elements, authoritatively recollected and combined, will in turn be assumed as empirical facts, and as such taken as the plain, indisputable evidence on which the pluralistic play of legal interpretation can be carried out. The lawyer's case will have constructed in this way their version of their empirical objective world. The same one inside which they will have previously inoculated the shadow of their cultural, ideological, subjective gaze. So is the thoughts or the dominating parts of society. But along the just outlined paths, the partisan factual world, indirectly legitimized by the fictional and mystifying maxim law makes its facts, becomes an instrument of social domination, whose action is more powerful the more it is presented as an expression of descriptive empirical language. Any apparently pluralistic debate about which legal rule is to be applied to the plainly determined facts and about which principle can be invoked to reach an equitable qualification of people's conduct will be cognitively undermined. The balancing between interpretation and axiological perspectives, for example, in intercultural conflicts, will deliver in any case an even result, if only because any discussion about the value hence preemptively, encapsulated in the categorization of what is assumed as the objective facts will be excluded at the outset. The dazzling objectivity of facts and their alleged epistemological sharpness, insofar as they are assumed as part and parcel of legal discourse, is the origin of the semantic darkness that law throws like a silencing umbrella on the more fragile, disempowered, and marginalized members of society. Lowers the resistance to recognizing the intrinsic plasticity of categories and their insistence on flaunting the axiomatic conviction that values and legal concepts are different things, are the main rhetorical weapons put in the social field to immunize the misogynistic and authoritative conception of law from an open criticism against the above assumptions. In many cases, they fail or merely pretend to fail to understand that indeterminacy is neither an intrinsic feature of language and thereby also of legal language, nor the consequence of an informative deficiency of the interpreters and the subjects deputed to apply law. With regard to the inability of lawmakers to grasp and predict all the possible situations destined to fall under the lens of law, positivist legal scholars have rarely observed that it is in all a marginal phenomenon. Furthermore, they invite us to consider that by and large, the legal language is clear and easily applicable by means of well-functioning schemes of referentiality. Just to stigmatize the imprecision of language, they make use of formulas like polysemy, open linguistic texture, think to hack, for example. Adapt the corresponding situation as systemic exceptions cannot otherwise be faced except by giving judges and officials the power to autonomously decide what is the law for the case. In distinguishing between easy cases and hard cases, precisely with regard to the semantic texture of legal rules, lawyers do not realize that there is no ontological distinction between the situation to be judged. Whether something is easy or hard to be categorized and thereby legally qualified depends on the semiotic context in which people's action is embedded. Nothing can signify by in itself, and it sits where an item caught in its solipsistic and unrelated existence. Meaning proceeds by relationships. Everything can undertake a categorical migration according to the situation and the axiological, teleological factors that trace its semantic borders. The same factors that in many cases produce metaphorical shifting of the element involved in the situation and in this way end up remolding the scope of the corresponding categories. What determines the easy or hard aspect of the case emerges from the semiotic webs underlying the morphological appearances of people's behavior. And it is exactly by means of a thoughtful fathoming of these semionarrative webs, their relevance and the determination of which facts are at stake, of course. The charge of injustice and discrimination lying in the shadow of legal words, dazzling sharpness, could be tackled and at least relativized. But what precisely is the utility of mining and bringing to the surface the semionarrative layers underlying both the production of categories and the morphological features that the human mind is superimposed on present phenomenal experiential fluxes? Why should such activity support the thinning away of the silencing shadow that law darkly casts beyond and after its words and authoritative categorization? The answer to this question, I think, is that making visible the semiotic and experiential backdrops against which the morphological features of things and phenomena take their shape allows the observer and the social actors, including the lawyers, to reopen the categorizing process. This does not at all mean that the pre-existent and previously known categories should be dismissed. Rather, their reinvestment in the depths of semiotic landscapes from which they have been extracted can reveal the continuity extent between what is inside the categorical borders and what is outside. In other words, the semiotic semantic exceedance inherent in the phrastic parts of legal provisions in the related categories. Such continuities can play a very relevant function in approaching the use of past categories in a critical and renewing way, if only because it can pave the way for metaphorical conflations between the categorical inside and the corresponding outside. Such conflation, in turn, may convey the immersion of a thirdness. I recall this here, Paolo Eritier's presentation. And this thirdness can be intended as the renewed categorical outlines, able to include what had been formerly left outside. If we merge the cognitive and social aspect of this categorical remolding, it will not be difficult to notice that such a renewal could provide a way to give utterance to the silenced voices of minority and marginalized subjects. From a legal point of view, more specifically, the discovery of the above semiotic continuities as an outcome from the surfacing of the implicit landscapes of semionarratives could allow for the exploitation of the competing relevance of previously overshadowed features of social experience with respect to the value sense included in the legal system. But some of this legal or this value sense will coincide with the access of legitimation of those very systems. This implies that when new threads of axiological theological relevance become visible by virtue of the mining of implicit semionarrative landscapes, simultaneously a semiotic circle will take shape, joining facts and the foundational value sense of the overall legal institutionalized fabric. Through this connecting movement, also the semantic relationships between values can undergo a process of categorical remolding so as to project this change as in a cascade effect on the categorization included in the descriptive phrastic parts of legal enunciation. Such circularity can induce, therefore, a collapse of the pre-existent categorization carried out by lawyers and delivered as corresponding to alleged clear content of legal concepts. The same clear content which is usually passed off as the result of the original, even if imaginary, semantic social contract signed by social members at the birth of the institutionalized legal system, or at least when, according with the constitutional guidelines, lawmakers have thought up the semantic contents of the legal rules they enacted. The overall semantic mobilization will transform as a consequence of the implementation of law in new social factual situation, in turn open to the new renewal, for this combination of words, of the cognitive categorization of process. The circular involvement of the hermeneutic process of the foundational value sense of legal system engenders a kind of semiotic continuity between the unremitting and teleologically driven renewal of categorization at a cognitive factual level and the molding of factual categorization from the law's perspective. In this sense, it is to be incidentally observed against a widespread but baseless argument that there is no ontological distinction between moral, ethical, and cognitive values. The same can apply inter alia to the aesthetic ones and so on. Think, for example, to Putnam and Mackey disputes on this topic. The overall process equates rather to, inter alia, we can say, an open and polyvocal construction of the world with respect to which law is to be intended as a means to plan its own future effectuality. The operative path outlined above requires, however, a change in the epistemic approach to the functional law in its very meaning. The lawyer's gaze should relativize its tendency to be focused on and maybe even obsessed by the search for legitimation as something lying in the past and should instead polarize itself from the semantic dialectics inherent in the law's projection toward the future, together with the implicit acceptance of its unpredictability. The meaning as well as the authenticity of both a legal provision, even lawmakers' intentions, dwells on the edge where words and experience, past and future, predicting and adaptive function of categorizations reciprocally interpenetrate. Only from the edge of this continually renewing hedge, a kind of threshold, can the past original meaning of law be genuinely and retrospectively ascertained. In the sense, the semantic past is in any case an implication, a bearing of the future. On the other hand, only such a cognitive opens could diffuse an ideological dominant use of categorization and the danger of a silent and surreptitious decategorization that it brings, at least according to Spinoza's motto, omnis determinatio est negatio, namely each determination implies a negation. That is the other side of the darkness after law. Furthermore, the above cognitive opens requires also the relativization of e-thought divide. Its importance, just to be clear, is not to be utterly dismissed, but rather curtailed in its scope. More specifically, it should be intended and employed as a pertinent heuristic and or pragmatic criterion, instead of being assumed as an ontological one and applied only in conditions of relative social semantic stability. On the contrary, invoking its validity even when the human mind must face the challenge of a changing environmental and social conditions could convert its intrinsic pragmatic wisdom into a mystifying and darkening smoke screen, dangerously and sometimes cynically aimed at overwhelming and stifling any criticism and pluralistic interpretation of both facts and legal values. To conclude, from an operative and technical point of view, the different approach just proposed should be brought to bear precisely when the medium tenor of a legal or judicial, but also more broadly jural syllogism is about to be construed. The hermeneutically and cognitively opening effect it brings could be enacted and further enhanced insofar as the legal qualification of facts is intended as a translational task, or even better, as a metaphorical transduction between the universes of discourse, two or more universes of discourse. This is because only the specific transformative attitude of a metaphorical transposition can open the doors of legal reasoning to a well-balanced consideration of the following two topics on results. One, the conflation between facts and values, and B, its relevance for an insightful and pluralistically responsive understanding of categories and attitude to change, that is to say, semantic plasticity, inherent in their authentic function. Thank you. So it's very difficult to conclude this. We have Olivier. Could conclude you, please.
Thank you.
Very laconic. Okay. Now,
thank you very much.
So thank you to all participants, to all speakers that undertook this enterprise with me, and so I can make other than sincerely thank you all. Thank you again.
Thank you.
So I can only say that good evening to you all. And thank you again for the patience in attending this long session. Good evening.
Good evening.
Thank you so much, Mario. Thank you.
Thank you.
What a pity could not.
Thank you. Thank you to everybody. Thank you, Mario.
Thank you, Mircea. Thank you, Paolo.
Thank you. See you tomorrow.
Daniele. Yeah.
Adesso non mi risponde.
What a pity could not to be in presence. Mario.
Uh,
Thank you so much.
okay, thank you to you, Paula, sincerely.